Hello, everyone. This is Fire, and I will be reading the Chicago appeal brief with R. Kelly. Initially, I put both briefings on the MIB and Spitfire, but when the MIB was taken down, I had to start it over, so it's not there. However, if you want to see the New York briefing that was dropped a few months ago, you can definitely look through my thread over there on Spitfire, and you can listen to that. This briefing is for Chicago trial. I will definitely be uploading this reading on both the MIB and Spitfire, whichever choice you like. Some people prefer the MIB, some people prefer Spitfire, so I will definitely be uploading them both. I probably will do them in segments, so it'll be easier for you. Now, I can't read that well legal terms, okay? I cannot enunciate some of these words or pronounce some of these words, so please bear with me. If you are a person who can read better or enunciate these words better, you can definitely reread these sentences as I go through them. Now, I will now also be reading this heading or this cover page, okay? We know that this is put in by Jennifer Bongine, who is R. Kelly's attorney. I would not be reading the inserts. And when I call inserts, is what they have to fill out to have approval on things to upload on behalf of the appellee, which is R. Kelly. I would not be reading these stuff, okay? This, okay? I would not be reading the table of contents, all right? I would not be reading the table of contents, all right? Also, when I read the brief, I will not be reading these case laws. Sometimes I may start and just say case law. I will not be reading the case laws. All right. Periodically in this reading, I will definitely highlight where I am so you can catch up if you're reading with me. If you just listening while you're at work, jogging, exercising, cooking, or whatever, it is what it is. Okay. Now, again, I do not know how to enunciate a lot of legal terms and some of these case law terms, so bear with me, all right? I do not even ask to sit up there and act like I know how to do it. I'm telling you up front, I don't, all right? So do not be leaving no crazy comments because I already told you. And furthermore, I do not know how to enunciate some of these case laws like the ones you see right here. I do not know how to pronounce some of those type of words, okay? So let's get to it. And like I said again, this will be uploaded on the MIB and it will be uploaded on Spitfire. Let's get it. This here is going to be 77 pages total. So we already start on page 7. So I'm thinking it's 70 pages now, okay? So the jurisdictional statement. The jurisdiction of the United States District Court for the Northern District of Illinois was founded upon 18 U.S.C. 3231. A grand jury sitting in the Northern District of Illinois charged the defendant by way of indictment with 4 counts of child exploitation in violation of 18 U.S.C. 2251A. 1 count of conspiracy to obstruct justice in violation of 18 U.S.C. 371, 3 counts of conspiring and receiving child pornography in violation of 18 U.S.C. 2252A 2 and B1, and 4 counts of child pornography in violation of 18 U.S.C. Docket number 93. The jurisdiction of the United States Courts of Appeal for the 7th Circuit is founded upon 28 U.S.C. 1291 and 18 U.S.C. 3742. A jury returned a verdict finding defendant guilty on 3 counts of 18 U.S.C. 2251A and 3 counts of 18 U.S.C. 2422B and on September 14, 2022, docket 335. The defendant post-trial motions were timely filed on November 15, 2022 with docket numbers 387 and 388. The post-trial motions were denied on February 16, 2023, with docket number 416. The defendant was sentenced on March 7, 2023, with docket number 428. The judgment and conviction was entered on March 7, 2023, docket number 428. A notice of appeal was filed on March 9, 2023. Statements of the issues for review. Number 1. Whether defendant convictions for sexual exploitation and inducement of a child must be reversed where the charges were brought outside the applicable statute of limitations. 2. Whether a district court abused its discretion when it denied the defendant's motion to sever the inducement counts related to Nia and Pauline from child pornography counts related to Jane. And 3, whether the defendant's 240-month above guideline range sentence were both procedurally and substantively improper. Statement of the case. On February 13, 2023, the government filed a 13-count superseding indictment charging the defendant Kelly with 1, 4 counts of violating 18 U.S.C. 2251A, the child pornography counts. 2, 1 count of conspiracy to obstruct justice in connection with his 2008 state court acquittal. 3 counts of violation of 18 U.S.C. 2251A related to receiving the aforementioned child pornography. And 4, 5 counts of violating 18 U.S.C. 2422B. The inducement counts, docket number 93, Kelly's co-defendant Daryl McDavid and Milton Brown were charged in connection with obstruction of justice and receipt of child pornography. After a 4-week jury trial, the jury returned a guilty verdict against the defendant as to 3 of the child pornography counts and 3 inducement counts. The defendant was acquitted as to the remaining counts. McDavid and Brown were both acquitted on all counts, docket number 335. The charges for which the defendant was convicted, counts 1 through 3 and 9, related primarily to minor 1 who used the pseudonym Jane at trial. 1 inducement count 10 related to minor 3 who used the pseudonym Nia at trial. And inducement count 12 related to minor 5 who used the pseudonym Pauline at trial. Right now, I'm going to read this footnote. The defendant will refer to minor 5 as Pauline, but advised the court that minor 5 initially used her nickname as a pseudonym which also started with the letter P. She later decided that she did not wish to use her nickname, so the pseudonym changed after the trial commenced. The superseding indictment in this case largely charged the defendant with conduct from the mid to late 1990s. Prior to trial, the defendant moved to dismiss all counts related to sexual exploitation of child on statute of limitation grounds. Docket 189. The defendant also moved pre-trial to sever the counts related to Jane from the remaining inducement counts where the evidence in connection with child exploitation of Jane, including video recording of the prohibited sexual activity, was significantly stronger than the evidence related to the remaining inducement counts 196. The district court denied both motions. Docket number 222. A. Evidence related to Jane. Jane testified that she was born in September 1984 and was raised in Oak Park, Illinois. When Jane was a junior in high school, she started being homeschooled because she was performing in a music group where other members of her family. Her entire family was involved in the music industry. Jane was introduced to the defendant through her aunt Stephanie Sparkle, who was a singer who had collaborated with the defendant. The defendant and Sparkle also had a romantic relationship. When Jane was 13 or 14 years old, she would hang out at the defendant's recording studio with her aunt. Jane explained that she would go to the studio and watch the defendant record with her aunt, and it was nice to see them working and producing music. Sparkle began encouraging Jane to foster a close relationship with the defendant. According to Jane, Sparkle told her to ask the defendant to be her godfather and instructed her to sit on his lap and rub his head. Jane wanted to have a closer relationship with the defendant and did what her aunt advised, asking the defendant to be her godfather. The defendant agreed. Jane told her parents that the defendant agreed to be her godfather, and they were pleased. Jane testified that her relationship and conversation with the defendant began to change, becoming more sexual and leading to phone sex. When Jane was 14, she and the defendant began to engage in sexual contact. The sexual contact involving touching, rubbing each other's genitalia, oral sex, kissing, and hugging. These occasions were frequent and occurred at the defendant's studio, his home, and on his tour bus. Jane's parents allowed her to stay with the defendant, including overnight. After Jane turned 15, she and the defendant started having sexual intercourse. The defendant started video recording the sexual activities with Jane when she was 14 years old. Jane testified that prior to taking the stand, she viewed the video footage of 3 separate sexual encounters with the defendant. One occurred in the living room of his home, one occurred in his bedroom, and one occurred in his room referred to as the log cabin room in the defendant's home. The video depicted touching and oral sex, but did not involve sexual intercourse. Jane testified that she was 14 years old on all 3 videos that she identified. The 3 videos were introduced into evidence as government exhibits 1 and 2. One of the defendants was captured on government's exhibit 1, and the 2 of the videos were captured on government's exhibit 2. The 3 videos formed the basis of counts 1 through 3 of the superseding indictment. B. Evidence related to Nia. Nia testified that she met the defendant in a shopping mall in Atlanta in 1996, where she was 15 years old. Nia was born in August of 1980. Nia obtained an autograph from the defendant at which he allegedly wrote down his phone number. Nia admitted that she did not discuss her age with the defendant and no longer had the autograph he gave her. Nia testified that the defendant asked her if she was going to his concert in Atlanta that evening. When she told the defendant she did not have tickets, the defendant arranged for her to obtain tickets. Nia did not attend the defendant's concert but began calling the defendant that evening. Nia explained that she had several conversations with the defendant and that she liked him. According to Nia, the defendant arranged for her to travel to Minnesota to attend his concert. Nia attended the defendant's concert but did not see him until the following morning in the hotel room. Nia testified that the defendant kissed her, touched and kissed her breast, and then masturbated. The defendant told her that he wanted her to visit him in Chicago. The defendant did not follow up on the invitation and did not book any arrangements for Nia to come to Chicago. However, Nia made her own arrangements and went to stay with family in Chicago that summer in 1996, unbeknownst to the defendant. Once in Chicago, Nia called the defendant. He invited her to his studio, but no arrangements for her to come there. Nia convinced her cousin to take her to the studio. Nia arrived at the studio with her cousins, and the defendant showed them around and took them to a waiting area where she could see him record. Nia and her cousin stayed most of the evening, but the defendant was recording and was not hanging out with Nia and her cousin of most of the evening. At some point, Nia told the defendant wanted to talk to her in the hallway, and Nia went into the hallway to see him. Nia testified he greeted me with a hug and a kiss and held on to her for a moment, and they kind of made out a little. Nia elaborated, I remember his hand being around my waist on my butt. And then he motioned his hand into my pants as we kissed. And he fondled my chest and he kissed. And we just made out without the time frame that were in the hallway. Nia stated he touched my vagina and caressed my bottom, my behind. Nia testified that before she left, she had a second encounter with the defendant. She stated they embraced, hugged. He held on to me. He held my bottom and things of that nature. It wasn't as long as the first one. It was more like, kind of like a goodbye, see you later. Nia never saw or spoke to the defendant again, but in 2002, Nia sued the defendant, and the case was settled for $500,000. C. Evidence related to Pauline. Pauline testified that she was born in October 1984 and grew up in Oak Park, Illinois with Jane. Pauline and Jane became friends in middle school. Pauline met the defendant through Jane when she was 14 years old. Pauline explained that when she was 14 or 15 years old, she discovered Jane and the defendant in the log cabin room. Jane was naked. Pauline testified that she had the first sexual encounter with the defendant when she was 14. She began having sexual encounter with both the defendant and Jane, which included oral sex. Jane eventually began having sexual intercourse with the defendant when she was around 15 or 16. When Jane discovered Pauline was having a separate relationship with the defendant, it became very problematic for their friendship. Pauline admitted that she continued to have a sexual relationship with the defendant until she was grown and was out of college. Pauline did not report to any authorities that she had a sexual relationship with the defendant when she was a minor until 2019. The government presented lengthy excerpts of videos recording depicting the defendant's sexual encounter with Jane in 3 separate occasions. Much of the government's case centered on the defendant's alleged effort to obstruct the state court's prosecution of the defendant in connection with one of the videos depicting his sexual conduct with Jane in 2008. The jury acquitted all defendants of the obstruction of justice count and all counts related to the receipt of child pornography. The jury also acquitted the defendant of 2 inducement counts related to Tracy and Brittany. The jury returned a verdict of guilty against the defendant in connection with the child pornography counts involving Jane, counts 1 through 3. The inducement counts as to Jane, counts 9, and 2 additional inducement counts in connection with Nia and Pauline, counts 10 and 12. The defendant's post-trial motions were subsequently denied. The district court judge sentenced the defendant to 240 months imprisonment in above guideline sentence. The district court vaguely referenced the defendant obstruction and concurrent sentencing guidelines when opposing the above guidelines sentence, with the exception of 1 year. The sentence was ordered to be served concurrent with the defendant's 30-year sentence imposed in the separate prosecution in the Eastern District of New York. This appeal follows. Summary of argument. The defendant Kelly was convicted on 3 separate counts of 18 U.S.C. 2251A, stemming from the creation of 3 videos depicting sexual conduct with Jane, who testified that she was 14 years old at the time the videos were created. The defendant was also convicted of violating 18 U.S.C. 2422B as to Jane, with whom he had a romantic relationship that lasted roughly 12 years and a friendship that endured until the defendant was indicted in 2019. The jury returned 2 additional guilty verdicts for violation of 18 U.S.C. 2422 as to Nia and Pauline. Nia testified at trial that the defendant followed her in a hallway at the studio on a single occasion when he was 29 years old and she was 15 or 16 years old. Nia stated that the encounter occurred the summer of 1996, but she could not state precisely when. For her part, Pauline testified that she began engaging in sexual conduct with the defendant when she was 15 years old. The prohibited sexual relationship endured long after Pauline became an adult, and she considered the defendant her boyfriend. The defendant was acquitted on all remaining counts of the superseding indictment, including the obstruction of justice charge, claiming the defendant obstructed his 2008 state court prosecution for the production of child pornography involving Jane. Indeed, Government Exhibit 1 was the same video that formed the basis of the defendant court state charges in 2008, for which he was acquitted. The defendant seek reversal of his conviction on the grounds that the charges of child pornography and inducement were time barred specifically. The defendant maintains that the 2003 amendment that extended the statute of limitations for conduct involving sexual abuse was inapplicable to the charged offense that occurred in the 1990s because Congress only intended it to apply prospectively. Thus, the statute of limitations for the charges on which the defendant was convicted expired no later than 2009 when Nia, Pauline, and Jane all turned 25 years old. Alternatively, the defendant seeks a new trial on the inducement counts related to Nia and Pauline, where the district court abused its discretion when it denied the defendant's motion to sever those counts from the child pornography counts related to Jane. Because the evidence in connection with the child pornography counts related only to Jane and was substantially stronger than the evidence supported the inducement counts related to Nia and Pauline. The inducement counts should have been severed to avoid the defendant a fair opportunity to defend those claims. There can be little question that the jury was unduly influenced by child pornography evidence that otherwise would have been inadmissible if the inducement counts were severed. Lastly, the defendant's 240 months above guideline sentence was procedurally and substantively improper. The district court failed to identify the basis on which he upwardly departed 72 months from the applicable guideline range of 135 to 168 months, except to suggest that it was based on acquitted conduct and the fact that the defendant's crimes would be punished more severely under the current guidelines. Both because the district court failed to state the definitive basis for its significant upward variance in violation of ex post facto clause, the subjecting the defendant to current federal sentencing guidelines rather than the applicable 1997 guidelines, the defendant is entitled to a new sentence hearing. Argument 1. The defendant convicted of sexual exploitation and inducement of a child must be reversed where the charges were brought outside the applicable statute of limitations. Because the statute of limitation on the counts for which the defendant was convicted, namely the child pornography and inducement counts, under no later than 2009, they were time barred. The defendant moved pre-trial to dismiss his indictment on statute of limitation grounds. Federal Rule Crime Procedure. Advisory Committee note. The district court denied the defendant pre-trial motion to dismiss. This court reviewed the legal issue on this case law right here. Okay, so we are right here. Federal law imposes a 5-year limitation period for most non-capital offenses, 18 U.S.C. 3282A. Over the years, Congress has provided a longer limitation period for offenses involving a sexual and physical abuse or kidnapping of a minor, of 18 U.S.C. 3283. At the time the defendant committed the conduct for which he was charged and convicted, namely the child pornography counts 1 through 3, and the inducement counts 9, 10, and 12. Section 3283 provided as follows. No statute of limitation that will otherwise preclude prosecution for an offense involving the sexual or physical abuse of a child under age of 18 shall preclude such prosecution before the child reaches the age of 25. 18 U.S.C. 3283, 1994. Consistent with the foregoing provision at the time of the charged conduct, the statute of limitation of offenses involving sexual abuse were intended until the victim minor reached 25 years old. Thus, Section 3283 extended the 5-year limitation period for the conduct alleged in counts 1 through 3 and 9 through the superseding indictment until September 2009, when Jane reached her 25th birthday. The statute of limitation for counts 10 was extended until 2005, where Nia turned 25 years old, and the statute of limitation for counts 12 was extended until October of 2009, when Pauline turned 25 years old. The defendant was not charged until more than a decade after the expiration date of the statute of limitations under the applicable law at the time of the alleged conduct, unless the subsequent amendments to Section 3283 applies retroactively in this case. The defendant conviction must be vacated and dismissed as time barred. In 2003, Congress amended the statute, extended the statute of limitations through life of a minor, 18 U.S.C. Congress did not express the intent for the 2003 amendment to apply retroactively. Consistent with the well-established presumption against the retroactive legislation, in 2003, the amendment is inapplicable to the charged conduct as any subsequent amendments to Section 3283. See the case law here. Let me read the book footnote. Congress amended the statute again in 2006 to its current version, which provides a limitation period for the life of the victim or 10 years after the offense, which is longer, 18 U.S.C. 3283 in effect at the time that the defendant offense, rather than the amendment version in effect at the time of the indictment. It is axiomatic that the criminal limitation statute are to be liberally interpreted in favor to repose. Case law. Retroactively is not favored in case law. Okay, so we're going to start right here because all these are case laws. I'm right here. I'm going to read to page 25, and that's going to be end of part 1. The Supreme Court has explained that the aversion to retroactive rulemaking is deeply noted in our jurisprudence and embodies a legal doctrine centuries older than our republic. Elementary considerations of fairness dictates that individuals should have an opportunity to know what the law is and to conform their conduct accordingly. Settled expectations should have not be lightly disrupted. For that reason, the principle that the legal effect of conduct should ordinarily be assessed under the law and existed when the conduct took place has timeless and universal human appeal. Case law. With these principles in mind, the district court erred when it retroactively applied the 2003 or 2006 version of the Section 3283 and denied the defendant's motion to dismiss on statute of limitation grounds. The United States Supreme Court in Lagroff set forth a framework for determining whether the federal statute of limitation applied to past conduct. The court's first task is to determine whether Congress has expressly prescribed the statute proper reach. If Congress has done so, of course, there's no need to resort to judicial default rules. When, however, the statute contains no such express command, the court must determine whether a new statute will have retro effect, i.e., whether it would impair right as party possessed when he acted, increased a party liability for past conduct or impose new studies with respect to transactions related completed. If the statute would operate retroactively, our traditional presumption teaches that it does not govern absent clear congressional intent favoring such a result. Okay, so that's some legal stuff from, excuse me, y'all. I gotta drink some water. That's some legal stuff for Congress when they be talking. Thus, under the Landgraf, if Congress is expressly prescribed that the statute applies retroactively or will apply retroactively, the inquiry ends. If the statute is silent on the issue, courts proceed to the second step of the Landgraf analysis and determine whether a new statute will have retroactive effects. Here, in 2003, amendment of Section 3283 contains no language expressly prescribing retroactive application of the amendment. Although the statute does not expressly provide that it may only apply prospectively, it implies language that point towards prospective application. The section twice used forward-looking modal verbs, would or shall. 18 U.S.C. 3283. No statute of limitation that will otherwise preclude prosecution for an offense involving a sexual or physical abuse or kidnapping of a child under the age of 18 shall preclude. See this case law. Characterizing the phrase would admit as a future conditional phrase. Case law here. Then I'm right here, you guys. There is no doubt that shall in an imperative, but it is legal clear that it is an imperative that speaks the future conduct. Imperative. I'm sorry, y'all. I know that word, imperative. That speaks future conduct. Okay. This is a case law. The word shall is a sign of the future tense, right? So I'm going to stop right here of the end of 15. And then I said 25, but I need to take a drink. I'm going to stop right here. This is going to be the ending of part 1. And then I'm going to start back up.